Well, thank you for coming along to view our webinar on business and divorce in Scotland. It is often said that one should never mix business with pleasure. Untangling parties' finances on divorce can be difficult enough at the best of times without bringing business interests into the mix. I'm Susie Mountain and I am a partner in Brodie's LLP's family law team based in Aberdeen. Aberdeen is a great market insofar as we regularly deal with clients who have or whose spouses have business interests. So the subject of today's webinar is something that frequently crosses my desk. Where business and relationships collide, it is important for clients to obtain married up advice, excuse the pun, to ensure that they have considered matters from all perspectives, particularly before making any big changes to the way in which they structure their business interests. A useful case in relation to the question of profit retained in a business during the course of a marriage is the case here, Wilson against Wilson. Now, in the Wilson case, it's a very interesting case. The husband had a shareholding in a farming company which he had acquired before the marriage. During the marriage, the company grew and acquired more property. The court held that this new property was not matrimonial and there was no basis on which to pierce the corporate veil. So to deviate slightly, what is piercing the corporate veil? This is something that is important that we cover at this stage. So the circumstances of when the court may lift the corporate veil are explored in the Supreme Court case of Prest against Petrodel Resources Limited.
We will now consider the various options available to extract one or both parties from a business relationship post-separation. Ideally, following separation, there should be a clean break between the parties and their finances. One point to note, which will not go into too much detail, is that if either party is a director of the company, they have statutory director duties to the company, including a duty to avoid conflicts of interest, a duty to promote the success of the company, duty to exercise independent judgment, and a duty to exercise reasonable care, skill, and diligence. This may be of particular relevance in acrimonious separations, where parties may act in a certain way with little regard paid to their duties to the company.